Okay, welcome back, class. We're going to go ahead and finish up Unit 3, Lesson 15 today. We're talking about amendments to the Constitution, different types of amendments that are offered in the Constitution. So we're going to go ahead and start off with overturning Supreme Court decisions. The 11th and 16th Amendments both overturn Supreme Court decisions. The 11th Amendment overturned Chisholm versus Georgia, which expanded federal courts' power and jurisdiction over state courts. This enforced the idea that federal courts have limited jurisdiction, and that took place in 1793. And then the 16th Amendment overturned Pollock versus Farmers Loan and Trust Company in 1895, which barred Congress from levying an income tax. We also can look at refinements, things that needed touched up in the Constitution. So these items that the delegates of the Constitutional Convention didn't anticipate. They couldn't see items like this coming forward in the future. So refinements started off with the 12th Amendment, and that had to change Article 2, Section 1 by creating the ticket voting system. This was because of the president and vice presidential fiasco that was the Adams presidency and Jefferson vice presidency, since they got first and second in the Electoral College. They needed to fix this problem because you saw how they didn't function together, and you couldn't have a president and vice president in opposite political parties. The 20th changed the transition of office holders from March to January. Because better technology and travel made it easier, we didn't need to have this extraordinarily long, from November to March, lame duck period for the president and for congressional electees. The 22nd Amendment limited presidents to 2 terms in response to FDR's 4 terms in office, breaking with the Washington tradition of only serving 2 terms in office. And then, lastly, the 25th Amendment addresses the vagueness of what should happen if a president becomes disabled in office. So what should happen upon removal of the president? The president can actually sign a letter releasing his duties to the vice president if injured. It also helps create a list of succession if something were to happen to more than just the president. Now, to address the picture I have on here, there's also morality, constitutional amendments that have been passed regarding morality and moral conduct. The 18th Amendment was the only one passed strictly regarding morality, and it had to do with prohibition. It banned alcohol sales in the United States, and we saw a boom of organized crime in response to this. So they ended up passing the 21st Amendment, repealing the 18th Amendment, also the only amendment appealing another amendment. Why was a Bill of Rights proposed for the United States Constitution? Let's start off with talking about the compromise between the Federalists and Anti-Federalists. Anti-Federalists like George Mason and Elbridge Gerry argued for one at the Philadelphia Convention. So the debate began at the Philadelphia Convention. Then you have James Madison, who argued rights like habeas corpus and ex post facto laws, bills of attainder, no religious test to hold political office, and the right to trial by jury in criminal trials were already protected in the body of the Constitution. So what would have been the purpose of restating them in a Bill of Rights? In his very first campaign, actually, James Madison had to run against future 5th President James Monroe, who had promised a Bill of Rights. So Madison had to actually change his stance to win his first election to the House of Representatives. Madison also objected to this because he thought trying to insert new sections of the Constitution would only hurt the odds of getting it passed. Now, George Washington and Thomas Jefferson also believed that a Bill of Rights would have been a good addition to the Constitution. George Washington said in his inaugural address that Congress ought to add amendments, and Thomas Jefferson said there should be freedoms of religion, standing armies, and monopolies even in the Bill of Rights, saying that the government should own certain monopolies to regulate that. The 17th Amendments were proposed by the House of Representatives, and the Senate approved 12 of the 10, and they were ratified in the states. Okay, so referring to the Bill of Rights, 17 of them were proposed. James Madison actually wrote and proposed those 17 to the House of Representatives. The Senate approved 12 of them. Then, according to the amendment process, either state ratifying conventions or state legislatures can approve this. As long as 3/4 of them approve it, that amendment gets passed. So 12 of the 10 were actually passed and became our Bill of Rights. So a lot of people assume the Bill of Rights were this combination of 10 amendments that needed to be passed. There were actually 17 that were proposed to be passed. All right, moving forward. What is judicial review and why is it so controversial? Well, judicial review is the power to declare what the Constitution means. It also gives the judicial branch the power to determine what acts of Congress and the President violate constitutional rights, which is a lot bigger power than what it seems, because if you think about it, giving the power to say what is constitutional, unconstitutional, they're interpreting the Constitution into their own views, and we'll talk about how that could potentially be scary. So let's start off with Marbury versus Madison and the Judiciary Act of 1789. You got to kind of feel bad for William Marbury in this situation. He was a highly qualified judge that had earned a position in the Adams administration. But as Adams lost the presidential race to Thomas Jefferson, he nominated a lot of judges across the nation called the Midnight Judges to keep his influence over the entire nation. Well, James Madison did not deliver the paperwork to administer Marbury his promotion. So he sued and said under the Judiciary Act of 1789, which was a piece of legislation passed by the United States Congress, the president did have the power to do this. So instead of ruling on the case and saying if Marbury Madison was correct, they took an entire different approach and argued that judicial review actually would be the power for them to say, well, the Judiciary Act of 1789 is unconstitutional. That can't be a law to begin with, so I'm sorry, Marbury, you were nominated illegally by a president. Alexander Hamilton argued that the Supreme Court would have this power in Federalist Number 78. Hamilton actually said that if the Constitution is the supreme law of the land, it's the judiciary's job to ascertain the meaning of that law. Now, the Supreme Court justice in charge of the Marbury v. Madison case that established judicial review was John Marshall. He believed that judicial review rests on the following premises. First, the Constitution cannot be changed by ordinary means because it is the people's exercised sovereign power, okay? So the people are the one that approved the Constitution, and therefore it cannot be changed lightly. Particular acts of the Congress, President, and states reflect temporary, fleeting views of what the law is. We can look at the 18th Amendment and see how society was kind of swayed in a negative way for a short period of time, banning alcohol. And we could argue that that was unconstitutional, but once it's an amendment, that's a part of the Constitution. So the only way that that could have been revoked was by another constitutional amendment. So certain temporary fleeting views and passions can get laws passed that sometimes are not for the best interest of America. Acts of Congress, the President, and the states that conflict with the fundamental law must be disregarded, and it's the judiciary's job to make sure those laws get disregarded. Unfortunately, our judicial branch doesn't always do a phenomenal job with that. And lastly, judges are in the best position to judge what the law is. They are without political pressures. They don't have to run for re-election. They don't have constituents that they are responsible to. They can simply do their job and interpret what they mean the Constitution to be. So therefore, they don't have any pressure from anybody because they can't be removed from office. All right, continuing why it was so controversial. Anti-Federalists such as Brutus, which was probably Robert Yates, feared that judicial review would be used to eliminate the power of state courts. And he would argue essentially that they could make state laws unconstitutional by simply saying that they are unconstitutional. Therefore, state laws were completely illegitimate because, remember, Hamilton argued that the Supremacy Clause would give the judiciary the ability to judge the law of the land, but the Supremacy Clause also would give federal government power trumping state powers. Once again, so federal courts could trump all state courts and eliminate state courts' power. We also want to move forward a little bit from our founding fathers and move on to Andrew Jackson. Andrew Jackson threatened not to enforce any Supreme Court decisions that he disagreed with. So once again, the Supreme Court may have the power to interpret the law, but somebody then has to turn around and enforce that law. So Andrew Jackson was the first president to say, sure, they can interpret the law, but I don't have to do what they tell me to do or enforce their decisions. Pennsylvania Supreme Court Justice John B. Gibson gave several arguments for why we should all be against some of the reasons for judicial review, why we should be against them. His argument was that legislatures represent the people whom are sovereign. By using judicial review, judiciaries are acting sovereignly. They're not elected officials, but yet they get to determine what the laws should and shouldn't be. He also argued that judicial review could lead to national turmoil if states, the legislature or executive, ignore the court's interpretation of the Constitution. So if just one president like Andrew Jackson truly ignored the results of the Supreme Court, then it would be pointless to have a Supreme Court. Or if the states completely ignored a Supreme Court ruling, it would be stupid to even have a Supreme Court. Judicial review also makes the judiciary equal or superior to the legislative branch. If the legislative branch, which is this deliberative body, takes months or years to pass a very delicate piece of legislation, and then the Supreme Court can simply say, no, we don't think that's constitutional, it's not going to get passed, even if it's an extraordinarily popular measure. And by our elected officials, the Supreme Court can go, no, not constitutional. Lastly, simply put, the judiciary is not infallible. They can make mistakes. They cannot be corrected in the ballot box, only by constitutional amendment. So when they make a decision that alters the entire United States, it affects everybody, and then it can't be changed unless there's a constitutional amendment. All right, ladies and gentlemen, that is it for this lesson.